And this group of individuals are here today to announce two lawsuits, one that's from the state of Washington and one from the citizens of Whidbey Reserve. And these are lawsuits that will be asserting multiple violations of the law by the United States Navy regarding the expansion of the Growler jet operations on Whidbey Island. Earlier this year, as many of you probably know, after ignoring objections from the community, the State Department of Health, and environmental advocates, the Navy finalized its decision to dramatically expand its Growler jet operations on Whidbey Island. The expansion will increase Growler jet takeoffs and landings to nearly 100,000 per year for the next 3 decades. Our lawsuit, which we are filing in federal court this morning, asserts that the Navy violated multiple federal laws by not doing enough to analyze the impact the Growler expansion will have on human health, the environment, and historical resources, and also failing to consider ways to minimize those significant impacts. Our lawsuit seeks to force the U.S. Navy to comply with the law and thoroughly analyze the dangers the increase in loud Growler traffic may pose to Washingtonians and our wildlife. Today, I'm also sending a letter to the Navy and the U.S. Fish and Wildlife Service advising them that unless they make changes, I will be adding more claims to the lawsuit in the future to protect threatened wildlife in our state. So let me do some quick introductions and then we'll get started. So to my right is Bill Sherman. He's an attorney in my office, so he's an assistant attorney general. He leads the part of our office that handles environmental litigation. So he's Counsel for Environmental Protection Unit Chief is his title, Counsel for Environmental Protection Unit Chief. And he's been leading our efforts here in the AG's office on our litigation. To my left is Attorney Paula Spina. She's the spokesperson for Citizens of Whidbey Reserve. That's a nonprofit on Whidbey Island that is filing a separate lawsuit on this issue. Also joined today, Bill Wilbur, who's the group's president, Marion Atwood and Michael Monson, who are directors. Jane Monson and Nancy Nordoff are members. Attorneys David Bricklin and Zachary Griefin. Also joining us are Donna Oswald of the Olympic National Park Associates. It's great to have Donna here because a little over 60 years ago, she was part of a protest hike along the Olympic coast in which she joined then Supreme Court Justice William O. Douglas. You may have read about this hike on the Olympic coast to protest threats to our Olympic coastline 60 years ago, and Donna was actually a part of that historic hike 60 years ago, so I've had the chance to get to know her since we did a similar hike this last year, so it's great to have Donna here. And also Rob Smith of the National Parks Conservation Association. Rob joined me and a crew on the 60-year anniversary of that hike. We were protesting potential oil development off Washington's coast that the Trump administration was considering. So Rob joined us on that hike, and he's aware of the concerns from park goers about the impacts of the Growler jets on the Olympic National Park. So thanks to everybody who's joined us today. So before walking you through our legal claims, I'm just going to give you a little bit of background about Growlers and the concerns around the Navy's expansion. Then we'll briefly describe how we believe the Navy has violated the law. We'll lay out what we plan to accomplish with our legal claims. Then you'll hear from Paula, who represents the citizens of Whidbey Reserve, about their lawsuit. So again, 2 different lawsuits, and Don and I will speak to those, and then we'll open up to your questions. So Growlers are aircraft that fly low in order to jam enemy communications. The Growler program takes place at 2 airfields at the Naval Air Station on Whidbey Island. Whidbey Island is home to many important wildlife habitat areas, including those for bald eagles, tufted puffins, harbor seals, and a threatened seabird called the marbled murrelet. Whidbey's Landing, as many of you probably know, is the nation's first national historical reserve, is adjacent to one of the naval station's airfields and less than 10 miles from the other airfield. Several communities, of course, schools, and state parks are also nearby. As many of the individuals standing behind me are aware, these aircraft are extremely loud. A private contractor for Citizens for Whidbey Reserve recorded sound levels above 100 decibels during Growler flyovers. The Navy itself has reported sound levels under the flight path of Growlers as ranging up to as high as 116 decibels. To give you a sense of perspective, a jackhammer is about 100 decibels. The noise a chainsaw makes is about 110 decibels. The Navy plans to gradually add 36 Growler aircraft to its fleet at the Naval Air Station on Whidbey Island by 2022, which would make a total of 118 Growlers. We do not know how many are there right now, but this is an expansion that is going on. The program expansion will result in nearly 100,000 annual takeoffs and landings. A couple of years ago, while the Navy was going through the decision-making process about the expansion, our Washington State Department of Health provided comments to the Navy about the potential human health impacts of increased Growler operations. The state put the Navy on notice of these potential issues. Those comments warned that exposure to noise levels similar to those at the Naval Air Station may pose a threat to public health. The Department of Health identified many studies showing that exposure to this kind of noise may cause sleep disturbance, cognitive impairment, and cardiovascular disease. The Department of Health also pointed to studies that provided evidence that noise exposure can impair children's cognitive skills and particularly reading skills. The law requires the Navy to study and fully consider the impacts of significant decisions that will impact Washingtonians and our environment before finalizing those decisions. The law requires that process. In other words, the Navy needs to look before it leaps. They did not do that here. Specifically, the Navy violated the National Environmental Policy Act. We'll refer to that probably as NEPA throughout this conversation, and the Administrative Procedure Act, often called the APA, a tool we've used repeatedly in our successful litigation against the federal government, by failing to sufficiently analyze the impact of the Growler expansion would have on human health, the environment, and historical resources. The following are two examples of the ways the Navy failed in its legal duty to study the impacts of the Growler expansion. First, the Navy ignored comments from the State Department of Health and failed to complete a thorough analysis of the negative impacts to health for both adults and children, including sleep disturbance and cognitive impairments. Second, the Navy failed to conduct a sufficient analysis of the impacts the expansion would have on certain wildlife in the area, including bald eagles and threatened and endangered seabirds. The Navy's analysis on the impacts to wildlife is insufficient in the following ways. First, the Navy assumes that birds and wildlife will just get used to the noise, just get accustomed to that noise, based on the fact that some birds and wildlife still live in the area with the current noise level. That's not good science. The amount and duration of noise matters to birds, and the Navy needs to look into that. The Navy also assumes the noise will have the same impact year-round, but of course birds have different breeding seasons and migrating seasons. The Navy's report might have found ways to minimize the harm to birds if it had actually looked into the differences between species and between seasons. The National Environmental Policy Act and the APA, the Administrative Procedure Act, also require federal agencies to show that they have taken reasonable measures to mitigate any negative effects caused by their actions. They need to take that into consideration. What could they do to mitigate the harm that this is going to create? In its review of the Growler expansion, the Navy failed to do that. It failed to consider reasonable ways to reduce the harmful impacts and effects the plan would have on human health, wildlife, or historic areas. In addition to the violations I've mentioned before, our lawsuit asserts the Navy violated the National Historic Preservation Act. Congress established the Eby's Landing National Historic Reserve next to the Air Station Reserve to protect the rural community and its significant resources. Extremely loud aircraft passing overhead spoils a serene, wild, and rural reserve. The Navy again failed to consider reasonable ways to protect the historic areas. The bottom line, with respect to the significant expansion of the Growler jet program, the Navy leaped before it looked closely at Growler's impacts on wildlife and human health. In leaping before looking, the Navy violated the law. Our lawsuit asked the court to declare the Navy's environmental impact statement as insufficient and therefore invalid, thus requiring the Navy to go back and start over. In other words, they need to go back and do it right. There's a reason the law requires the government to look before it leaps. Washingtonians deserve an accurate assessment of the impacts of the Growler jet expansion on human health and wildlife, and a thorough review of strategies to reduce the harms, and that's exactly what the law demands. We are also initiating a process to file an additional claim under the Endangered Species Act. That process starts today with the letter that we are sending to the federal government to give them 60 days notice. I won't go into the legal details of that, but before we can file that claim, we have to give the federal government 60 days notice that we might file it. That letter is going out today, and it's linked to our press release as well. Just to wrap up my thoughts, I'll say that, obviously I take suing the federal government seriously. This is our 41st lawsuit against the federal government. As many of you know, we've not lost a case yet. We've won 21 cases, we've lost none. I think it's also fair to say that if you're filing a lawsuit against a military branch of the federal government, you take that especially seriously. I'm from a military family. All my many uncles served in the armed forces. My father was a Navy man. He was proud of his Navy service, I can assure you. But as we were chatting before we came in here, my late father, was also a believer in following the rules. He believed in that. And look, despite being a Navy man, I'm confident he would think this is the right thing. The Navy's got to follow the law just like everybody else. They're no different. So they have an obligation to perform their vital and important national security function. No two ways around that. But they have an equal duty to the law and to Washingtonians and to our environment that we take very seriously. They have an equal obligation to follow the law when fulfilling their important mission. And the importance of their role in our society does not relieve them of their legal obligations. And that's what our job is, to make sure they're following the law, taking the right steps, so there's a transparent process that considers all the impacts to human health, all the impacts to our wildlife, all the impacts to EB's reserve, and looks at potential ways to mitigate that. The bottom line is they simply haven't done that, and that's not okay. So with that, Paula is going to speak about a related but separate lawsuit. I just want to emphasize these are two different lawsuits, but obviously quite related, and she'll speak about those, and then we'll take your questions. Thank you, Paula.
Thank you, Attorney General Ferguson. Before I get started, I would really like to take a moment and thank the Attorney General, and in particular two of his staff, Assistant Attorney General Bill Sherman and Aurora Yankee, I hope I pronounced that correctly, who have been working with us and who have put this lawsuit together. They took a hard look at the Navy EIS and the record of decision. They took a hard look at the Navy actions on Whidbey, and they're the first of our political representatives to really stand up for us in a big way. We have other representatives, our senators and our representatives have helped, but this is a huge step, and we really want to thank them. For many years we've been fighting this battle. Corps was founded in 2012 in response to the Navy bringing the Growler to Whidbey Island. In 2005, the Navy issued an EA, an environmental assessment. It's a way around doing an actual EIS. And in 2005, the Navy wanted to bring the Growler to Whidbey Island, and it represented to the people of Whidbey and Washington State that there would be less impacts from bringing the Growler to Whidbey Island than there were from the current generation of aircraft they flew there, the Prowler. They told us they would only fly 6,120 operations per year at the OLF. That's 2 operations per touch and go, so about 3,000 operations. They told us for most operations the Growler was less loud than the Prowler. None of those things were true. We didn't know they weren't true until after the statute of limitations expired, when they started flying, basically in 2011 and 2012. In 2012, the citizens of Central Whidbey rose up to say, this is not what you told us, this is not what you promised, and that's when Corps was founded to represent the citizens of Central Whidbey. This fight has grown well beyond Central Whidbey, however. The presence of the Growler, the expansion, bringing in more Growlers, more operations, has had a profoundly negative impact upon the whole region. Many of you have seen news reports about how the Olympic National Park and the Olympic National Forest have been impacted by Growler training. They moved all of their electronic training from the deserts of Idaho, Mountain Home, Idaho, over to the Olympic National Forest because it was more convenient for them. It's closer. But in doing that, they destroyed the tranquility in the Olympic National Forest. Same thing is true for EB's National Reserve. As Attorney General Ferguson mentioned, it's the very first National Historic Reserve. It was established by Congress to provide a piece of history for the Northwest that's essentially akin to Williamsburg in the East. It's our history. It was to show how the consistent agricultural life from the early founders, how it was, how it exists, and to preserve that tranquility in that agriculture. That has been destroyed by this Growler expansion. Our community is suffering. We filed a lawsuit, and we've been working with the Attorney General's office. We filed a lawsuit because The Navy just would not listen to us. When they were doing their DEIS, their draft EIS, and they were doing their community meetings, thousands of people showed up. Thousands of comments were submitted, almost all of which were negative on the plan, to say this is not appropriate, this is insupportable, and this will devastate our communities. The Navy ignored all of that. They ignored it in their EIS, and they ignored it in their record of decision. We finally have somebody willing to stand up and speak up for us and say, no, you can't ignore that. So thank you again. As I said, our communities are hurting, but not just Central Whidbey, the whole region. I saw news reports out of the Methow Valley the other day about how the Growler training over there is disturbing their peace and their quality of life. You regularly see complaints from the Kitsap Peninsula, from Port Townsend, from the San Juan Islands, from as far away as Victoria, British Columbia. The Navy hasn't listened to anyone. Life in Central Whidbey has become hellish. We literally are told noise is no big deal, but the military uses noise as a weapon. They regularly use extreme noise against our enemy combatants, and we feel essentially that that's the same thing that's happening to us in our homes. You cannot go outside while the Growlers are training. They're flying 200 feet above your head. We've measured the noise in the range of 105 to 120 decibels. Hearing protection only gives you about 30 decibels. It's still above the danger threshold. Inside our homes, we regularly measure sound from 90 to 110 decibels. We're told this is the new normal, you just have to get used to that. But what they're really telling us is that we don't deserve to have the same rights as everyone else, that we don't deserve the same human and civil rights, that we should just move if we don't like it. Well, we're not going to just move. We don't like it. We're going to stand up for our legal rights. There's been a long fight, but we're not going away. And now we have a huge ally, and I'm hoping that the rest of our representatives can take a hard look, as did the Attorney General's office, and determine that this just isn't right, that American citizens shouldn't be exposed or subjected to this. We'll be around to answer questions afterwards. Thank you.
Thank you very much. So just a final thought I'll just say is, as I travel the state, I've spent a lot of time, obviously, in the areas impacted by Growlers, Rotary Club meetings, you name it. I'm asked about this issue all the time when I'm over there. There's a big issue to that community, as folks in this room, I hope, our visitors here understand. So it's one I hear about a lot. And so we just really appreciate, and I know I speak for Bill and our legal team, there's been a lot of conversation over a very long time. I appreciate the patience of individuals here, for us to put together a case or think about a case or make a decision about a case. A lot of time and thought goes into that, and so I've been communicating to these folks, hey, we're going through a process here, and that often takes a long, long time. So we appreciate their patience with that process. We want to make sure if we're bringing a legal case against the government, it's a good one, and that's a lengthy process for us. But just really appreciate all the collaboration, and frankly, the feedback that I've heard from many individuals impacted by these Growlers in the past several months in particular. With that, we're open to any questions that you have, and Bill Sherman, again, from my team, will undoubtedly be helping me with any questions about the litigation. Yes?
I noticed in this document, paperwork here, it says that the future flights might affect future habitat. Is there any measurable impact on the natural environment that occurs now, currently?
So I'll just repeat the question, so some folks might be on the phone. So I think the question, to paraphrase, is we talk about the impacts on these additional flights that are coming with these additional Growlers. What are the impacts currently with the existing Growler program? What part of our litigation includes that? Bill, do you want to maybe speak to that part about what the litigation side? Yeah,
I'd be happy to. So what we're able to challenge with this litigation is the Navy's record of decision and their environmental impact statement about the expansion of the Growler fleet. That's what we're able to challenge in this. The Navy's environmental impact statement did assess the existing level of effect, but that's not really what it's focused on. It found that there are various noise effects on people, on animals, on habitat. So those do exist. Those are heavily documented. This lawsuit challenges the new additional effects, not the past effects.
Thanks. Other questions?
What would you say to critics who say that's what you get when you move near an air station?
Well, a couple of things. Paula may want to speak to that, but what I would say is that everybody has to follow the rules, right? If the Navy wishes to expand their Growler operations, they've got to follow rules. These rules, by the way, are not especially complicated, okay? Just want to be clear about that. They're not especially complicated. They're laid out very clearly in these federal laws, and you simply have to follow them. That's being a good neighbor. That's being a good member of our community. And I've spoken to many members on the community who value the Navy being there and the presence of the Navy over many years, but they say, hey, this isn't right. They're not following the rules that everybody else has to follow. So to be candid, I think that's sort of a false choice, right? Folks can live on Whidbey Island. Yes, the Navy can be a neighbor and a good neighbor, but they've got to follow the rules, and those rules are not complicated to follow. So I think the question is best posed to the Navy. Hey, why haven't you followed these rules? And what we're asking is literally nothing more than they need to go back and go through that process. And that is good for transparency, so the people of the affected communities can see what those impacts are. And also, I want to emphasize, it requires the Navy to examine how to mitigate those impacts, right? What are steps they can take? And one thing I've heard repeatedly from members in the community is, and I think you heard this from Paula, that they don't feel the Navy is listening. And I've heard this from a lot of very reasonable people who have tried to work with the Navy on this issue, and they've said, hey, we just can't seem to get anywhere. They're just going forward regardless of our concerns. And that's not okay when they have to pay attention to those concerns, specifically in following the legal steps that require transparency of what they're doing and the impacts of those steps.
May I-
Yeah, absolutely, Paula. Yes, go right ahead.
Specifically answer your question, the Navy has a couple myths that it likes to put out. One is that noise is not harmful. Well, the world scientific community has taken a stand to say that noise is very harmful to human health, to the environment. So that's just not true. The second myth they love to put out is what you just asked. Well, isn't this what you get when you move next to a Navy airstrip? Well, there are many people in our community whose families have lived on their homes far longer than the Navy had an airstrip there. Secondly, that airstrip was built in World War II for prop planes. It was never built, never intended to be used for jets. The Navy has had to give itself waiver after waiver because that airstrip does not meet its own requirements for an airstrip for that use. So it just ignores its own requirements. Thirdly, if the Navy felt that this was the only place it could do this training, then the Navy had a responsibility a long time ago to buy the property, to buy all of it, to stop people from building there. They did not do that. They were complicit with Whidbey Island government. Admiral's estates, a huge subdivision, was allowed to be built in the 1960s. The Navy was complicit in bringing homes there, and now their argument is, well, too bad if you live there. Well, that's just not right. That's not how we deal in America. If the Navy needed that place, they should have bought it. And a last point on that issue, the U.S. Congress has given the Navy and the other military branches millions of acres of military reservations for exactly this type of training. They have a military reservation down in Southern California, 1.2 million acres, that's barely used. It is used for experimental aircraft. It could easily be used for this training with absolutely no impact on sensitive environment, no impact on endangered species, no impact on civilian life. But they don't want to go there. They prefer to be where we are.
Just one thing I'll add before taking the next question is that I think Paul has addressed sort of the community's perspective on that, but the point you make is it's not a legal argument, right? I mean, they're going to have to address legally the steps they took or did not take and outline what the concerns are, and that's where this fight will take place, in a federal courthouse, where they've got to respond to our claims under very specific federal laws that require very specific steps, and we're confident in our case along those lines. Yes?
Is launching legal action against the Navy, a military branch, any different from launching legal action against like a department within the executive branch, which you've done before? Does that pose particular challenges And then also,
Yeah.
Are there any other examples of where a state or neighbors have launched legal action against the military elsewhere in the country with success or not success?
So I won't be able to speak to the second question, so if others know, I'll defer to others on whether outside of Washington, what's happened. I know Bill and I have talked about specific cases in other parts of the country. I don't know if they match that fact pattern, but I'll leave it to Bill or others to speak to that. On the first question regarding litigation against the federal government, I guess what I would say is that each of the now 41 lawsuits against the federal government, speaking broadly, presents its own challenges, right? We often, different challenges identify different parts of the federal government. It could be the EPA, it could be the president himself, it could be the military. And so I guess what I would say is that each present their own challenges, but there's a lot of commonalities as well. So for example, talking about the Administrative Procedure Act, in the 21 cases we have won against the administration, the federal government, many, the majority I believe, come from their refusal to follow this Administrative Procedure Act, okay? So it's relatively straightforward federal law that the current administration simply refuses to follow, and that's often why we prevail in court. So of course there are differences depending on what part of the federal government you are filing litigation against. Certain rules have to follow or not follow can be different as well, but there are also some commonalities in terms of the claims that we bring, and I point to the APA as being one that is a very consistent theme, very consistent cause of action that we brought, frankly, successfully against the federal government. Bill, I'm not sure if you can speak to the other question or not.
I think maybe as a general matter, so I think the question was, is this law used to success? And I want to reiterate something the Attorney General said, which is that the laws that we are suing under here are not specific to the military. The National Environmental Policy Act was adopted in 1969. It's referred to as the kind of core environmental charter of the federal government. And at the bottom, it's really a look before you leap law. It says, we're not going to prescribe exactly what the government has to do in the end, but on the way, it needs to take a hard look at environmental impacts. And that's going to be true whether it's the Navy, that's going to be true whether it's the Fish and Wildlife Service, it's going to be true regardless of the Department of Transportation, every federal agency, military and non-military. And so, as you might imagine, in those 50 years, there have been many lawsuits under that law. And so there's a very well-developed body of case law that says what the government has to do, whether it's the Navy or anyone else, what the government has to do when it's taking that hard look at environmental impacts. We're very confident that the claims that we're bringing are well-founded in case law that say exactly what that hard look needs to mean for the Navy or for any other agency.
I'm just going to see if anyone, I'm not sure if we have folks on the phone or not, but just in case, it looks like there might be. So I just want to make sure there's a chance for, if anyone on the phone has a quick question, feel free to, this would be a great time if you've got one before we wrap up.
Yeah, it's Bellamy from PNKX.
Yes, go right ahead.
I have two questions, actually. I'm not sure if you can answer both of them, but one would be, there are a lot of issues with the military. I'm thinking of sonar and whales and other things that folks have been concerned about over the years. I want to know, what was it specifically about this case that made you decide that it was worth it and a good case to pursue? And then the other thing is, I just want to be clear about, aside from creating a real environmental impact statement and looking at mitigation, what might the outcome of this be in terms of delaying the deployment or actually moving the planes elsewhere? What do you see the outcome of this case being, assuming it's successful, or maybe also just in the short term?
Sure. So Bill, take your second question. I'm sorry, do you mind just repeating the first part of your first question? I want to make sure I answer it correctly.
Yeah, just what was it that moved you to actually go ahead and you said it's a tough threshold to decide to sue the military. There are lots of cases against the military. What was it about this case that made you decide to go forward?
Sure. So I'll take the first one. Bill will address second. Paul may want to jump in as well, but okay. But I'll start first, and the next voice you'll hear will be Bill's. In terms of what was sort of the decisive factor in moving forward, which I think is the thrust of your question, I guess let me put it this way. So I've had many conversations, as I've indicated, with many community members impacted by the noise of the Growler jets. Those are important conversations, but as I emphasized in all those conversations, is I said, hey, I need to talk to Bill, I need to talk to my legal team about whether there's a legal challenge there. There are many concerns or issues that I may have, or members of people of Washington State may have with action by the federal government that do not rise to a legal challenge because our legal claims are insufficient, or I cannot bring the lawsuit, all sorts of reasons. So that's why we spend a lot of time looking at the legal side of this, and that's what I've been focused on. While very mindful of the impacts to individuals, obviously, right? I hear those conversations, but as a lawyer for the people of the state, what my job is to focus on, do I as Attorney General have a legal case against the Navy, and can that stand up in court? And so that has been our focus, and my team knows, before filing any litigation against the federal government, I've got 3 questions that I ask, and those questions are Washingtonians being harmed? Do we have good legal arguments? And can I, as Attorney General, bring the lawsuit, as opposed to an individual like folks are doing here? If the answers to those 3 questions are yes, yes, and yes, then we're moving forward. If there's a no in there, and there often is a no in there, then we do not. It may sound simple, but in a way, I found those 3 questions really get to the heart of each legal issue before me. And so in this case, to answer your question directly, the answers to those 3 questions are yes, yes, and yes. We feel most assuredly Washingtonians and our environment are being harmed. We feel we have good legal arguments, as Bill has talked about, and we are confident that I, as Attorney General, can bring the lawsuit as well. So for me, that's the focus when I go through making a decision on whether or not to file the federal government, and we're very, very disciplined about that approach. Bill?
Sure. So to follow up on the second part of the question, we're asking for the court to do several things in response to the lawsuit. One, we're asking them to vacate what's called the record of decision. That's the Navy's formal document that says this is what we're going to do. We've done the environmental impact statement. We've done that study. This is the decision step. We're saying that the court needs to throw that out because the environmental impact statement was insufficient. So that would essentially send the Navy back to go, needs to start over and do a supplemental or a new or a revised environmental impact statement that takes that hard look. It's important to think about what the National Environmental Policy Act is there to do. What it's there to do is to make sure that before the government makes a decision that's going to have an impact on the environment, it knows what that impact is. And then the assumption is, then with that information, the government can make better decisions that can minimize and mitigate that impact. So we're confident that once the Navy takes that step and provides a full and complete hard look at environmental impacts, that the Navy will be able to then make a better decision about how and what to do with the Growler fleet on Whidbey. So I don't know whether Paula has additional things to say on that.
The only thing I would add is that in our lawsuit, Citizens of the EB's Reserve, one of the things we'll be asking for is a preliminary injunction. As I said earlier, in 2005, the Navy represented in bringing the Growlers to Whidbey Island that they would only do 6,120 operations a year at the OLF. They're currently on pace to exceed 24,000 operations at the OLF, and we believe that they've already exceeded somewhere in the range of 13,000 to 15,000 operations. One of the things we're going to try to do to get some relief for our community is to get them to stop using the OLF for the rest of the year, since they've already exceeded their 6,120 operations.
So I want to thank everybody for all their questions. We'll be around, obviously, for folks in the room. If you have additional one-on-one questions, we're happy to answer those. I just, again, really appreciate everybody who's here from the community. I mean, just so much. It's been, and again, I just want to emphasize, appreciate their patience. There's been a lot of conversations over a long period of time, and what they've heard a lot from me is, appreciate the feedback. I'm going to go talk to Bill now. And so they've been patient, but we just, kind of to earlier questions, we just need to make sure in this office that we are being methodical in our approach and carefully constructing each of these lawsuits for reasons that I think are pretty clear. And we think that has been a successful path for us, and candidly, we anticipate success in this case as well. Thanks so much for being here, and look forward to additional questions. Have a great day, everybody.